Imagine a doctor who notices concerning symptoms in a patient but fails to order appropriate tests, resulting in a misdiagnosis. Or a property owner who ignores a broken staircase that later causes someone to fall and get injured. These scenarios represent failure to act, a critical legal concept with serious implications. Failure to act occurs when a person or entity has a legal duty to take action but neglects to do so. This negligence by omission can result in both civil and criminal liability, depending on the circumstances and the harm caused. For a failure to act claim to be valid, 4 key elements must be established. First, there must be a legal obligation owed by one party to another. Second, there must be proof that this duty was breached. Third, the plaintiff must have suffered an actual injury. And fourth, there must be evidence that the defendant's inaction directly caused the injury. Legal duties to act typically arise from special relationships or statutory requirements. For example, doctors have duties to their patients, employers to their employees, and certain professionals like teachers and social workers are mandated reporters who must report suspected abuse. In personal injury law, negligence often involves an action, such as a driver hitting a pedestrian. However, inaction can be equally negligent. A business owner who refuses to repair a hazardous work environment, like a faulty elevator, can be liable for injuries that result. Failure to act extends beyond personal injury into multiple legal domains. In contract law, when a party fails to perform agreed-upon duties, it constitutes a breach of contract. In medical contexts, a doctor failing to diagnose an illness when a reasonable professional would have done so may constitute malpractice. Corporate executives and financial advisors have fiduciary duties to act in the best interests of their clients or shareholders. Government agencies can be liable for failing to maintain infrastructure or enforce safety regulations. The consequences of failing to act when legally required can be severe. Civil liability may require compensating victims for their losses. Criminal charges might apply in cases where the failure results in serious harm, such as manslaughter charges for failing to report child abuse. Professionals may face disciplinary actions, including license suspension. Defendants in failure to act cases have several potential defenses. They might argue that no legal duty existed in the first place, that the harm was not reasonably foreseeable, or that intervening causes were responsible for the damage. There are also important exceptions to consider. If you begin helping an injured person, you cannot simply abandon them. You become obligated to continue helping or stay until medical assistance arrives. Additionally, encouraging someone else to commit a harmful act can make you liable for the resulting injuries, even if you weren't directly involved. Some jurisdictions have Good Samaritan laws that may either protect those who provide voluntary assistance or impose a duty to act in emergencies. These laws reflect society's evolving moral standards about our obligations to one another. Understanding failure to act is essential for individuals and businesses to recognize their legal responsibilities and the potential consequences of inaction. While not all moral duties are legally enforceable, the law increasingly reflects society's expectations that those with special duties or capabilities will take appropriate action when needed.